very much for joining us, or welcome back, for this third interview of the second series of European law interviews. The interviews are sponsored by the Jean Monnet Chair, which is part of the EU Commission Training and Education Programme promoting innovating learning programs related to EU studies. We have the great opportunity to interview Professor Nicolas de Sadeleer. He is a professor in EU and environmental law at Université Saint-Louis Brussels and Université Catholique de Louvain. Good morning, Professor.
Good morning.
Thank you very much for rejoining us. We will discuss today tax law, custom duties, and charges equivalent to custom duties. So it started with the EC Treaty, which had a provision, Article 3(1)(a), calling for the removal of tariff barriers. Then this was retaken in the TFEU with Article 3(a), and the removal of tariff barriers is considered as the internal element of the custom union. So we have two very important provisions here, Article 28 and Article 30 TFEU. Those provisions prohibit member states from applying custom duties on interstate imports and exports, as much as charges having equivalent effect, called CEEs, notably custom duties of a fiscal nature. We will start with the first general and easy question. So, Professor, can you please define a custom duty?
Firstly, it must be noted that the treaty law does not define the concept of custom duties. Strictly speaking, a custom duty can be defined as a charge determined on the basis of a tariff, which is specifying the rate of duty to be paid to the importer, to the host state. As a matter of fact, custom duties are discriminatory in nature, since all custom duties have been abolished by member states since the 1st January 1970. Only charge having an equivalent effect to custom duties are of any practical importance nowadays.
Okay, so thank you very much for this explanation of the notion of custom duty. Then can you please define the charges having equivalent effect to custom duties?
Well, again, one can be struck by the fact that there is no definition in treaty law. The Court of Justice has been interpreting broadly that concept. That can be defined as any particular charge, however small, and whatever its designation or its mode of application, imposed on domestic goods or on foreign goods by the reason of the fact that they cross a frontier of one of the member states, and that cannot be qualified as custom duties in the strict sense. The terms, whatever its designation, signifies that irrespective of the qualification given to the charge is likely to fall within the scope of ambit of Article 30 inasmuch as it impinges upon free trade by reason of the fact that the good is crossing a frontier, and the terms imposed unilaterally on domestic or foreign products means that the scope of Article 30 must be differentiated from the scope of ambit of Article 110. Article 30 applies exclusively to charge levied at the frontier. In addition, I would like to stress that the prohibition of a charge having equivalent effect has been laid down in 1957 by the treaty drafters with a view to avoiding that member states circumvent the prohibition to lay down custom duties.
Okay, thank you very much. We are now more familiar with the notion of custom duty and CEEs. So this brings us to an additional question. Are custom duties and CEEs discriminatory in nature?
Admittedly, the form of taxation, the purpose of the charge, the description, the modes of levying the charge, the use of the revenue cannot alter the classification of a charge as a CEE. By way of illustration, the Court of Justice has been qualified the contribution to a German solidarity fund for the return of illegally exported waste as a CEE, irrespective of the fact that such a fund complied with international law and secondary law, and no matter the environmental dimension of the fund. By the same token, the Court of Justice ruled on a charge levied by the Sicilian authorities in Italy on pipelines importing gas from Libya, and irrespective of the environmental objective of the charge, the Court of Justice took the view that it was deemed to be a CEE for the purpose of Article 30.
Okay, thank you very much. We are now more familiar with the notion of custom duties and CEEs. So this leads us to an additional question. Are custom duties and CEEs always discriminatory?
Yes. All in all, they are discriminatory in their own rights on the ground that they are levied by reason of the fact that the good is crossing a frontier in one of the member states of the EU.
Okay, thank you. So we mentioned two provisions of the TFEU before, so Article 28 and Article 30. Those are prohibiting custom duties and CEEs. Can you please tell me if the prohibition is absolute?
Yes, in addition of the no de minimis rule, the prohibition laid down under Article 30 is absolute. Member states cannot invoke Article 36 clauses or a rule of reason. So member states should definitely avoid to raise charges that are likely to be deemed to be qualified as CEE for the purpose of Article 30.
Okay, so thank you. It might be a bit confusing for the students watching us to understand the real difference between custom duties and CEEs on the one hand, and then quantitative restrictions. Can you please draw a dividing line between Article 28 and Article 30, and then Article 34 and Article 35?
The scope of Articles 34 and 35 is broader than the scope of Article 30. Article 34 is likely to cover any technical measures likely to hinder or to impair intra-community trade, whereas the scope of ambit of Article 30 is, strictly speaking, restricted to either custom duties or charges having equivalent effect to a custom duty. Okay,
thank you very much. Once again, it might be important to draw a dividing line between Article 28 and Article 30 and Article 110 of the TFEU.
Yes, Article 110 is related to general taxation schemes and condemns discriminate charges raised within such general taxation schemes. So Article 110 does not apply to charges that are levied by the reason of the fact that a good is crossing a frontier.
Okay, thank you very much. It's very useful, especially for students. We will now move more deeply into the topic. So, charges affecting equally domestic products and imported products might have the effect of benefiting to national products. So, my question will be, Are these arrangements falling within the scope of ambit of Article 30 or of Article 110 of TFEU?
Yes, indeed, this is an extremely complex question. As a matter of fact, the proceeds or the revenues of such a charge that is equally imposed on national and foreign products might be redistributed to the national distribution or to favor the national production. Under such circumstances, the charge would be qualified as a charge having an equivalent effect, no matter whether it is applied equally to domestic and foreign products.
Okay, thank you very much. I will go back on what you said just a few minutes ago. So there is a general prohibition of custom duties in Article 30. So it basically means that it's very broad and it's absolute, actually. Yeah, that's what you said.
Yes.
Okay,
indeed.
so member states tried several times to use grounds of justification a bit similar and even to invoke Article 36 and the rule of reason to be able to adopt several measures that are against Article 28, but the court is always refusing to allow exceptions. There is one very slight exception in the case law. I'm going to read a short excerpt and then you might comment if you don't mind.
Yes, please.
Okay, so the court has held that the charge escapes this classification as a CEE in 3 situations. So the first one is if it relates to a general system of internal dues applied systematically and in accordance with the same criteria to domestic products and imported products alike.
That's Article 110 we just discussed.
That's it, as you said. Then the second is if it constitutes payment for a service in fact rendered to the economic operator of a sum in proportion to the service. That's the second one.
Yes.
And the third one is, or again, subject to certain conditions if it attaches to inspections carried out to fulfill obligations imposed by community law. So
Yes,
those are the 3 categories, 3 exceptions. Can you please explain a bit those exceptions?
Well, we shall discuss the scope of ambit of Article 110 in a further interview. Of interest now it's just to focus on the second exception.
Okay.
One should bear in mind that under most national regimes, the lawmaker or the constitution is drawing a dividing line between impuestos in Spanish and taxas in Spanish, between les impôts in French et les redevances in French,
Okay.
or between belasting in Dutch and heffing, still in Dutch. The idea is that on the one hand there is a general scheme of taxation with no service rendered to the company subject to the charge. On the other hand, specific charge are levied on the account that a specific service is rendered to the beneficiary of that service. And so the Court of Justice has been endorsing in its case law the distinction drawn by the different councils of states and constitutional court or Cour de cassation.
Let's go back to the second exception. It's possible for a payment for a service to escape the grasp of Article 30. Under which condition is it possible? Maybe it's more than one condition in conditions.
Under truly exceptional circumstances, the court admits that member states can charge specific services rendered to the taxpayer. But firstly, there must be no obligation to resort to the service subject to the charge. In other words, the service may not be imposed upon the taxpayer. Secondly, the benefit must be individual, must be actual, and must be tangible. Thirdly, the due or the service must be proportionate to the real cost incurred by the taxpayer. So the amount of the due must be commensurate with the service provided by the national authorities.
Okay, and do you have a concrete example?
Yes, the German Waste Solidarity Fund is a good case in point. That fund was set up by the German authorities in order to cover the expenses related to the repatriation of illegally exported waste to Sicily or to Western Africa or to Asia. And the German authorities argued before the Court of Justice that in doing so they complied with both the Basel Convention on Transfrontier Movement of Waste as well as with the regulation on waste transfrontier movements. And they claim that they were rendering a service to the German waste exporter. The Court of Justice dismissed that argumentation in claiming that the service was compulsory and irrespective of the fact that the German authorities had to comply with international law and secondary law, the conditions laid down formally by the Court of Justice were not fulfilled.
Okay, so we will now move to the third category, so the charges for inspections required by EU law. Can you please explain under which conditions it is possible?
Well, inasmuch as secondary law authorizes member states to levy a charge with a view to enhancing the control of goods imported or exported or in transit, such a charge won't be qualified as a CEE for the purpose of Article 13, to say the least. But there are very few illustrations in the environmental field. I imagine that the regulation on the transfrontier waste movement provide for the possibility for the member state to levy such a charge. But I've seen nothing similar in the CITES regulation, for instance.
Okay, so there is a big debate, especially now in the news with the Warsaw conference on climate change. So we have to go back on our issue and topic. So member states are keen on levying eco-taxes on electricity, for example. The problem is that many countries, for example Belgium, export most of their electricity. So eco-taxes on electricity might be equivalent to a charge on exports only. What's the view of the court on the matter?
Well, the court ruled on the matter in the Outokumpu AU case, a Finnish case. The Finnish authorities had been setting up a general systematic taxation scheme on electricity, under which the rates varied according to the production methods. Energy produced by nuclear reactors were more heavily taxed than electricity produced by dams, for instance. That scheme had been challenged by different Finnish companies, and claimants put forward the following idea. Swedish electricity imported into Finland was taxed at the time of the importation, whereas the Finnish electricity produced in Finland, as a matter of course, was taxed at the time of production. And given the distinction between importation and production, Article 30 should apply. The Court of Justice dismissed this argument and took the view that the charge was applicable similarly to foreign products as well as to Finnish electricity, because the charge was levied at the same market stage. As a result, Article 110 applied, and the taxation scheme escaped the clutches of Article 30. By the same token, there was a case in Austria. The Austrian authorities levied a charge on landfilling waste, some of which came from Italy. Some economic operators argued that given that the waste was imported into Austria from Italy, such a charge was raised by reason of the fact that the waste crossed the Austrian-Italian border. That argument was again dismissed by the Court of Justice on the ground that the tax was levied by the mere fact that the waste, be it Italian, be it Austrian, be it German, was discarded in the landfill.
Okay, thank you very much, Professor. This is the end of the third interview of our second series of European law interviews. The program is sponsored by the Jean Monnet Chair. If you are looking for more information on the matter, feel free to check Professor de Sadeleer's book called EU Environmental Law in the Internal Market and published by Oxford University Press. So today we discussed tax law, custom duties and CEEs. We started by a short introduction on custom duties and then on CEEs. After that we saw that they are discriminatory in nature and that there is an absolute protection in Article 28. Then we discussed the dividing line between all these articles and what we saw in previous interviews. And finally, we dealt with very important and current examples, especially electricity. Thank you very much for watching this. We will see you next week for another European law interview. Bye!